the most shockingly unjust parts of the criminal justice system is bond, otherwise known as bail. And today I'm going to be sharing 5 of the most shocking facts about the unjust bond/bail system in California, ranked from least shocking to absolutely most shocking. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be going through the 5 most shocking facts about the unjust bail system in California. So number 5, and this one may be fairly obvious, is that those who have money get to fight their cases from the outside. Those who do not have money get stuck in jail. Now, you may or may not know this, but when you post bond, when you give money to a bail bondsman, they typically charge you between 8 and 10%. So let's say that your bond is $50,000, which is really common for a low-level felony charge, and you give the bail bondsman $5,000. First of all, you have to have that $5,000. Some of them will give you a payment plan, but you're going to have a significant amount up front. But you also will never get that money back. So those who have money get to post that bond, get out, pay for a private criminal defense attorney. Those who do not have that money either have to choose between an attorney and freedom, and that freedom may be short-lived, because if you don't have a good attorney, perhaps you're going to be going back into jail to do time or even prison. So you may have to choose between those, or you may have to just fight your case from the inside if you don't have enough money for either one. So that one's fairly obvious. Number 4, and this one, if you've been part of the criminal justice system, may also be obvious, is that prosecutors know this and they will use it against you. So how does this work? Let's say that on Friday you are arrested for domestic violence, and let's say you didn't do it, you were just in a loud argument with your significant other, police came out, they said, sorry, we've got to arrest someone, they set your bail at $50,000, and now on Monday you're going into court, and you don't have $5,000. Maybe you are a broke college student. Maybe you just don't have that money. Maybe you don't want to spend the money because you have children to support. Maybe you would have to choose between rent and paying that money and getting out. And now the prosecutor sees that you're there, you're in custody, and the prosecutor knows that they've got you. So maybe they offer you, hey, you know what, if you plead guilty today, we will let you out. Yeah, you'll have a felony on your record. In some cases, you'll have a strike felony under the 3 strikes law on your record, but at least you'll get out today. And for many people, when you're thinking, okay, or I could stay in here for probably 3 months, maybe half a year, and wait to fight it, and that time I lose my job, my family can't pay the rent, whatever it may be. I basically lose my whole life in that time. Maybe, yeah, I get a not guilty verdict eventually, but I've lost everything. They know that they've got you. Most people are probably going to take that deal. Whereas if you were able to bond out, got picked up Friday, maybe late Friday night, early Saturday morning, you post that bond because you or your family have that money. Monday morning, if you show up to court, you're not taking that deal. You're going to say, no, Mr. Prosecutor, you can take that felony and you can shove it. Maybe I'd accept a misdemeanor down the line, but I can take my time. I'm on the outside. And prosecutors in Los Angeles County use this against you. They know that you are desperate. Shocking fact about the bond system number 3 is that bond can be increased at your first court date. Now, maybe you're like that poor unfortunate guy I just mentioned who on Friday he's not able to bond out. He comes to court Monday, he's still in custody. They raise his bond. Who cares? He's in the same situation. Maybe he takes that first deal. Maybe he stays and fights it. But if he doesn't have the money, he doesn't have the money. But what about guy number 2? So let's say he bonds out late Friday night, early Saturday morning. His friends, family, they gather all of their funds. They scrape this together. They don't want him in jail. And then he shows up at court on Monday, and the DA says, you know what? We don't think that that bond was high enough. We think that he is a flight risk. Or, you know what? I don't think that the police charged him with enough things. We're going to add some new charges in here. They can actually raise his bond. And what does that mean? That means that he's going to go into custody. He's going to go back to jail unless he's able to post even more money. So let's say they already paid $5,000, right? His friends, family, they gathered all of their money, they put that money up for his bail, but that was all that they had. Now he's going to go back into jail. He's going to be in the situation of guy number one, but he's also going to be out $5,000. Now, if you're watching this and you have a case in LA County, I don't mean to scare you. This is on a case-by-case basis. Most of the time, we as lawyers can tell, you know what, I think that this case is undercharged. But not always. And sometimes the prosecutor will have information that we don't have, that you don't have, that they surprise us with that morning. And the judge has to assume, and I'll get into this a little bit more in a moment, but the judge has to assume that the new charges, that you're guilty of the new charges when setting that bond. So maybe you want to say, yeah, but that other thing they're saying I didn't do. It doesn't matter. They might increase your bond if there are new charges added, and most of the time they will. Now, of course, your attorney, there's something that we can do about that. Your attorney can have arguments ready to make sure that your bond is, or to give you the best possible chance of not having your bond increase at that first court date. But we are attorneys. We are not magicians. And this is something that when I first found that out, I was totally shocked by it. Now we're at number 2. We're getting more shocking as we go on. Number 2 is that the bond can be raised at any time during your case by the DA adding new charges. So let's say you've been fighting your case for 8 months, but all of a sudden, perhaps there's a protective order saying you can't contact the alleged victim. The alleged victim contacts the DA and says, hey, you know what, I don't have any proof of it, but he called me. It was from a blocked number, but I answered it, and I heard his voice. Well, now the DA can add new charges at your court date for a violation of a restraining order, and the judge can actually increase your bond based on that. Now, like in number 3, your attorney can have arguments ready for why your bond should not be increased, but again, the judge has to assume, for the purposes of deciding whether or not to raise your bond, that it's true that you did commit those new charges. Okay, now we're at number 1. Now this is the most asked of thing in the whole bond system, in my opinion, and we saw this a lot during COVID. And I was shocked how judges didn't really seem to bat an eye at this. It didn't really seem to bother anyone except for, of course, me as a defense attorney, I'm sure other defense attorneys, and the defendants. Because bond can be exonerated, meaning that it goes away as though you never paid it, if the DA takes too long to file charges against you. So through no fault of your own, let's say that you are guy number, I think it was 2, who is able to, his family, friends, gather all of their money, right? They post bond. Maybe you go to your first court date. It's 3 months after you were arrested because you bonded out. They set it up for 3 months, and the DA still hasn't filed charges. You go to their office that day. They say, oh, you know what, we're still reviewing it. Well, let's say it's a felony. They have 3 years in general to file most low-level felony charges. Let's say a year later they decide, you know what, we are going to file charges against you. They send you a letter in the mail, and they say, hey, come to court on this certain date at this certain time. You're like, all right, I'll go. You're not expecting it to be too dramatic necessarily. You already posted bond. You know that you're in that position of guy number 2 where you can fight these charges. You're not in custody. Hopefully by this time you've paid your friends and family back. You've kind of moved on from this. Well, the shocking thing is that the judge may look at your case and say, well, you didn't post any bail. And you're like, no, Your Honor, I have the receipt right here. I definitely posted bail. And the judge says, well, it was exonerated. You're like, exonerated? What the heck does that mean? Well, what it means is that when you post bail, you generally, unless you have tens of thousands, hundreds of thousands that you're willing to be away from some period of time, you use a bail bondsman, right? So you pay the bail bondsman, and the bail bondsman posts money, let's say it's $50,000, posts that money with the court. But then at a certain point, the bail bondsman is going to get that money back. Well, how it works is that at a certain point, it is not a fixed point. The court may decide to exonerate, give back that money to the bail bondsman. Now, if you have a good bail bondsman, hopefully they let you know, hey, your bond has been exonerated, right? And hopefully, if you end up in the situation of them saying, hey, your bond was exonerated, you didn't post anything, I don't care about your receipts, hopefully your bail bondsman won't charge you again. But what I saw, especially during COVID, when they would say, the courts are shut down, no one can go into court during this time, and still now they're filing charges, especially in Orange County, that could have been filed during COVID. They're just taking their time. What many times will happen is the bail bondsman will say, okay, well, if your bail is going to be set at $50,000 again, you're going to have to pay me another $5,000. And what if you can't? If you can't, it's as though you never paid any bond in the first place. So I've actually seen, and thankfully not my clients, but I've seen people get taken into custody who initially posted bail, who showed up for their court date on time, early, and the judge cannot take into account that they posted bail the first time when deciding whether or not they should be out on bail now. So they may lose out on whatever they paid the bail bondsman, and yet still go into custody and end up in a situation of the first guy. I hope that you found this video helpful. If you do have a case in Orange County, LA County that you need help with, please feel free to give me a call, or you can book a consultation down below.